Mr. Schoenfeld, could I make sure I understand what you mean by coercion? You say in your brief that there are three things that cannot be done. The state cannot say you can't go to a private school or a religious school. The state cannot say you must affirm certain beliefs. And the state cannot say that unless you that you're going to be disqualified from benefits because of your religious beliefs. Is that the universe? Those are the three situations in which there's coercion?
No, Your Honor. I think what this court said in Ling is that coercion is found when there's a tendency to coerce individuals into acting contrary to their religious beliefs. So, for example, in the
present... It goes further than that. So suppose a school says, we're going to talk about same-sex marriage. And same-sex marriage is legal in Maryland, and it's a good thing. It's moral. It makes people happy. Same-sex couples form good families. They raise children. Now, there are those who disagree with that. Catholics, for example, they disagree with that. They think that it's not moral, but they're wrong, and they're bad. And anybody who doesn't accept that same-sex marriage is normal and just as good as opposite-sex marriage is not a good person. Now, what if that is what the school teaches students?
I think that's absolutely coercion. I think where I found the line between exposure and coercion in your presentation, Justice Alito, was this is the state of the law in Maryland and elsewhere in the United States. People can fall in love, get married, even same-sex couples. Some people believe in it, Catholics don't believe in it, and then it stopped. And then it was directly derogatory of a particular set of religious beliefs. It was avowedly so, and that, I think, under any fair reading, would give rise to a coercion or a discrimination claim.
So you can, the school can teach students certain moral principles that are highly objectionable to parents, and that's okay.
Yes.
They can't opt out.
That does not burden their free exercise. There's no constitutional requirement of completeness in these contexts. A school could easily teach that evolution is one theory and it is the correct theory, and I don't think there's any constitutional problem with that. Certainly if a student taking a test said, you've taught me about evolution, here are the principles of evolution, I'm reciting them to you, but I don't agree with that, and my faith teaches me differently. No teacher would penalize the student for saying that, and if the teacher did, that would certainly give rise to coercion.
Now let me, the opposite end of your spectrum of possibilities is exposure, which you talked about over and over. What does that mean? I would think that exposure, and we can take the example of same-sex marriage. Again, exposure is telling the students that there are a lot of people who marry a person of the opposite sex. There are also people who marry a person of the same sex, period. Leave it at that. That's exposure. If you go beyond that, is it still exposure?
It depends on the context. I mean, I think Uncle Bobby's Wedding is teaching third graders or second graders precisely that. It's telling it through a story. And the fact that in that case, it's Uncle Bobby and Jamie rather than in Uncle Peter's Chinese-American wedding, it's Uncle Peter and his wife.
Well, don't you think, I mean, Justice Sotomayor and I were discussing this before, and we could have we could have a book club and have a debate about how Uncle Bobby's marriage should be understood, but I think it clearly goes beyond that. It doesn't just say, look, Uncle Bobby and Jamie are getting married. It expresses the idea subtly, but it expresses the idea this is a good thing. Mummy, said Chloe, I don't understand. Why is Uncle Bobby getting married? Bobby and Jamie love each other, said Mummy. When grown-up people love each other that much, sometimes they get married. I mean, that's not subtly sending a message this is a good thing.
I think that's a way of a mother consoling her daughter who's annoyed that her favorite uncle is distracted and doesn't have time for her. But even if the message were, some people are gay, some people get married, I don't think there's anything impermissibly normative about that. It is a story that is being used to teach students that just as in the 99 of the 100 books that we read about couples, it's a man and a woman, there also may be a man and a man.
I mean, why is the Montgomery County Board of Education in this argument running away from what they clearly want to say? They have a view that they want to express on these subjects. And maybe it's a very good view, but they have a definite view, and that's the whole point of this curriculum, is it not?
I'm not running away from anything the board has used to defend this. I think what's in the record is that the board wants to teach civility and respect for difference in the classroom. There is obviously an incidental message in some of these books that these life choices and these lifestyles are worthy of respect. I don't know how you can teach students to respect each other without teaching that. If the book were about, Uncle Bobby's wedding, they get married, and the rest of it is, that was awful, then there would be a serious equal protection violation in the presentation of that curriculum. So the incidental message that these things ought to be normalized and treated with respect, I think, is simply part of the work that the school is doing in cultivating respect in a pluralistic school.
Well, the plaintiffs here are not asking the school to change its curriculum. They're just saying, look, we want out. Why isn't that feasible? What is the big deal about allowing them to opt out of this?
So a couple of answers. I think on the facts of this case, we have the natural experiment of the schools permitting these opt-outs and then finding that it was not administrable. It wasn't true in every school.
Well, why is it not administrable? They're able to opt out of the health class, right?
The health class is taught discreetly. There's a meeting, mandatory meeting for all parents where they are told exactly what's going to be taught in it, and they're given the option of opting out of the unit of instruction, not the particular.
Well, that's how you define the unit of instruction. You could define the unit of instruction to include the reading of these storybooks.
And that's not compelled as a matter of Maryland state law.
It's not compelled as a matter of state law, but why should it not be compelled as a matter of the free exercise clause of the First Amendment? There's nothing. What is infeasible about doing that?
So again, I think the experience of the schools with respect to these 5 books showed that it was infeasible. And let me give you an example. Let's say the school, an exquisitely competent and well-resourced school, is able to say, on Tuesday at 9 o'clock, we're going to read Uncle Bobby's Wedding. We're going to make arrangements for alternative space. We're going to give suitable supervision for our 6-year-olds. And we're going to give them an alternative assignment that accomplishes the same ELA goals. Let's say that happens, right? That they were able to pull off. The next week, someone says, that was my favorite book ever. I'm going to pull it off the shelf, and I'm going to ask Alan to sit down and read it with me. What happens then? The teacher can't simply summon a librarian to come to the school, say, those were the kids who opted out of that lesson.
Well, I don't think you're really answering my question. Why can't this all be put? We're going to read Uncle Bobby's Wedding and these other books, but we're going to read it during a period of time that includes the health class, and children are already able to opt out of that, so they can opt out of reading these books.
I think there's no constitutional obligation to treat these books that introduce people to LGBT characters in a curriculum that is meant to teach about different matters.
I'm not